coming into place is from the July 2025. Now, we've got 11 key changes here, Scott, and to our owners, we want to give a comprehensive update. I do apologise about the audio technical glitch there. Starting from the first one, which is Strata Managers Service Reporting, 6 monthly reporting from Strata Managers. Unfair contract term protections, and we're going to go through what it means for schemes, owners, corporations, and associations. We're also going to be covering off these new sustainability requirements. Another one of developer accountability. So we've seen a bit of information come through in terms of developer accountability. We're then going to look at accessibility infrastructure, what that means for schemes. And we'll be touching on assistant animals. And that's really a provision of sort of evidence and single forms of evidence. Minor renovation processes, floorings, etc. And then we're going to go through additional items and changes in terms of improvements of repairs and maintenance changes, Section 106. Embedded networks, some record inspection fees government has applied, along with some committee duties and chairperson functions. So, Scott, part of the SCA in our last webinar, we had a lot of questions on what's the Strata committee training looking like. But what we know is we haven't had that clarified, but we're going to try to dumb that down, and I might put you in the spotlight and ask you some questions on that. But what we know is we've got some additional functions for a committee and a chairperson as well undertaking their roles for the owners corporation and their associations. So starting off, we have Strata Managers Service Reporting, and from the 1st of July, Strata Managers, they must provide 6 monthly reports rather than the annualised reports to their owners corporations. Now, these reports aren't just covering financial. We're looking at aspects of finance, meetings, insurances, work orders, delegated functions if we're dealing with aspects of technical matters, advice, tribunal scenarios. And I've put some applicable legislation. I know it's always not a good point there, but I think, it's always good to see where they're making these changes. But in looking at this, Scotty, we're seeing a lot more sort of requirements in terms of, I guess, strata managers being transparent. And what do you see in this regard as, the provisions of the SCA sort of looking at this? 6 monthly reporting versus the annualised reporting. It's going to be quite interesting.
Look, it's going to place a significant burden on the strata managing agents to provide this information. But, in saying that, transparency is the key. And I think the intent of the legislation is certainly to make things more transparent for your customers and for all the consumers out there. And it's key. It really is a key aspect. If you really think about it, we're talking generally about their greatest asset, their home or their investment. And why wouldn't we provide them as much information as we possibly can? I think it's a good move forward.
And looking at that sort of, when we look at this reporting, there's so many mechanics we look as a business in terms of strata managers provide. If it's things of repairs, maintenance, quotes, insurances, compliance, etc. There's so many mechanics that work with the business. I actually like this because it shows an element of transparency. We're so used to seeing the financial aspects, but there's so many elements that connect to this. So we're looking at items of compliance, insurances, services, work orders, quotes, dealing with defects, disputes, etc. These are all detailed, which really shows, it's not only just for the strata managers, but you've got aspects of, frontline, and you've got all the people that make up these organisations and support, which not only shows how things operate. I know as a strata manager for so many years, I couldn't see how one person could do all these items these days. And it really does that. So, as a sort of provision of commitment, we've looked at this and we've said, a delegated function report is great, but what about an analysis of the building and how that's functioning and what's going on? So we will be producing these reports to our associations and schemes to give them an understanding of what's been happening. The committees are very involved, and hats off to them. But for owners, it will be a great provision.
But it will, Paul. Paul, it's going to provide the volunteer committee members some tools to understand what they're actually dealing with. It's going to make them, I believe, or provide them the ability to make decisions with more transparency and more understanding. So again, I think the intent of the changes, although quite onerous for strata managing agents to put this together, I think it's a good thing. And you're right, it engages everyone within your business and everyone in most strata companies' business, because the strata manager has a lot of people standing behind them or behind her or him, delivering a sense of professionalism. And this just adds to that professionalism.
And importantly enough, the professionalism is also the tracking, the live recording of details. So record keeping is not just about filing documents, but it's about recording your day-to-day functions. So I know as an organization, as a team of strata management and as an organization, we've actually had to talk about recording details and functions. And, technology is a great thing when you can record the details and what you do and how you do that. There is one live question, which I think is relevant, is that a building manager's report? Now, this is not for building managers. This is for strata managers reporting directly. Will we see some additional changes to that? Yes, we will. That will come later in the year, I believe, in building managers. They will have similar obligations that will come up, and we'll definitely give you some more information there as well. Now, I'm probably going to go through the most technical stuff now and then go through the most sort of client active committee operations. But what was really interesting, Scott, we looked at unfair contract terms, and a lot of these things in over the 18 months have been in discussion. But what intrigued me is, out of all these years in strata management, the protection now under consumer law protection, specifically when we look at the Property Stock and Agents Act, the Fair Trading Act, owners, corporations, associations had that consumer protection. And there's this real need of unfair contract terms protection to schemes, not just for a strata managing agent's contract, but goods and service providers as well. This is a real aspect of a game changer in terms of owners corporations, because it seems as though it's got to be also not just on the owners corporations end, but service providers being aware. And I know the Strata Community Association New South Wales has really advocated for these things. So when you're seeing these changes, it is heading in the right direction, is it not?
Well, look, it's this new piece of legislation known as the unfair contracts terms is a federal piece of legislation, so it's federally been implemented, and it's meant everyone's had to review their contracts to make sure the terms were fair both ways, not just one way, but both ways. And look, of course, we're going to have to. We've certainly dealt with it in terms of the strata management agent contract, and that's been adjusted to comply with not only the federal legislation, but of course there's been some state legislation that's changed also to complement the unfair contract terms. So the agency agreements have been updated to do that. But of course, you need to extend that thought pattern across all contracts that the owners corporations enter into. Look, it'll be a learning curve for many of the small suppliers because they're not geared up to have a look at these things. But I think that the strata managing agent has a duty or a fiduciary duty to explain to the their clients, the strata committees, that we may need to have to chip through these. The strata manager can't do it because they're not lawyers or solicitors, but they certainly can guide them in the right place. So when contracts do get renewed, or when the major contracts you are reviewing on a regular basis, it's potentially time to have a really good look at those and engage with your contractors in good communication and work the best contracts out for both parties.
Thank you, Scott. And look, it's really interesting because, I mean, you have a provision of engagement which may relate to work orders, etc. But irrespective of the size of engagement, especially in contract terms, you're really starting to focus, if you're just doing standard cleaning or, your weekly gardening, things that come on routine services, it's really focusing on a requirement that I would like to see, and that what we're going to see for our clients to take up a contract, to know what they're dealing with day to day and ensuring that they're fairly treated in that respect. Now, I'm going to put you sort of in the spotlight because, I mean, what we're looking at doing as an organisation and also with our specialist solutions team here is, having contracts reviewed, making sure those reasonable terms are there, making sure clients see copies of these draft contracts. Now, I'm going to put the SCA in the spotlight. Is there any guidance to strata managing agents and for their owners corporations of standard form contracts we can see to help in that respect? Because I guess naturally you could build contracts at way out, and solicitors will have to do that. But I mean, a lot of these contracts that are entered into putting aside the major remedial contract building works in routine services, was also applicable there. I mean, so surely there'll be some sort of recommendation of a templated contract that could be applied, would it not be?
Look, we're certainly looking at those aspects, and even the Office of Fair Trading are certainly looking at that as well. They're looking to standardise a agency agreement contract for strata managing agents, and I think there's a lot of technical things in and around it that they're struggling with at the moment, because not all contracts are going to be exactly the same. You might say you've got a standard cleaning contract, but there's different aspects to it. So there might be the 10 or 15 basic clauses, but then there'll be some at the end that respectfully are related directly to the individual or the individuals, owners, corporations. But yes, I think there's a lot of work to be done around that, Paul. And yes, SCA is looking at that.
And in my sort of scenario as a strata manager, maybe I've been here too long and you've done the same sort of timing in this regard, but we're sort of getting to the path where strata managers will have to have a basic knowledge of what offer and acceptance and reasonable terms of contract terms will be, to be able to inform our schemes that, look, I don't think it's reasonable that you're paying for their professional indemnity or their public liability insurance, for example. I was actually shocked to see that actually occurred. I've never seen that in close to my 20 years, but these are things specifically that have caused this to open up, I'd imagine.
Yeah. And they're really technical questions, and I'm not sure we're geared to do that, but they're things that we need to make our owners corporations aware of. And people do degrees at university specifically just on those clauses, if you know what I mean.
Yeah, definitely. In that regard, these contracts are commonly handled by strata committees, and times where general meeting resolutions are required, they're there attached to a notice of a general meeting. But I think there's going to need to be more verbiage and guidance as we come through this time to give some guidance in that respect. So it depends the type of contract, if it's with the committee or the owners, but they are visible. I think talking about this, owners' accessibility to this information online, having that record there is also essential. So definitely be able to address in due course. This one's an interesting one that came up, Scott, and this was a thing that came up when we talked about unfair contract terms. Now, new agency agreements were introduced. They had to be introduced.
Yes.
I think it was a long time. There was a lot of cases, a lot of provisions, enhancements of services that agents were undertaking that just wasn't just administrative, and was in that real advisory sense. But this one was really interesting that drew my attention. Defense against prosecution. And I thought, what is this? Like, you look at this and you talk about legal defenses, etc. Come on, we're managing communities, we're working with people here, this is people's homes. But the interesting part about Section 57 stating an obligation of an agent and their breaches that can occur, a new clause is being introduced in terms of an agent ensuring that if we're giving that advice and the scheme's having an obligation to comply as a third party. That was a bit of a grey area, I think. And when this came up, I thought anyone that sees this and sees it as an announcement that says, this is your prosecution, we don't have indemnity. I did get quite a few inquiries from our owners, and I just explained the difference between our insurance, their insurance, and what this actually meant is falling in the right place of undertaking works, and fire compliance is a huge one these days. And I should have said that. I could end up with a million questions here. But one of those things is achieving compliance. And if the party that was responsible in owning it, being the corporation or the association, if they didn't fulfill their obligation, and an agent would have to follow through, this sort of meant that the person liable making or responsible to make those decisions was still held accountable. Is that the way we're seeing that in that respect?
Well, that's my understanding of it. And of course, with the new unfair contract terms, some of these things have been watered down, particularly in our contract. It's not as as strict because it just didn't meet the new standards. And as you say, it's changed significantly.
So when we look at that, it is making, in my opinion, when I look at this, is managers have got to stay proactive. And we stay proactive, we give that advice, we make sure we direct. I always love to use the example, we're only as good as the instructions we get, in committees and owners corporations will be as good as the advice they receive. So time to time, there may be intervention, but these are as these new regulations of building standards requirements come up, they will also come into play. So it will be an interesting part. We're seeing a lot more regulatory changes, fire safety, the Design Building Practitioners Act, and it does create some grey areas. And I know fortnightly we do a lot of training and weekly update sessions on this. But we will ensure we'll fulfill this information if it's through our newsletters, etc. And if there's anything that can be provided, we would love doing that as well. Work health and safety, I think, is also a big one.
Yes, there's going to be more steps involved and more considerations for the owners corporation, and dare I say, likely more cost as well for the owners corporation to make sure that they comply with these requirements.
Yeah, I think they've thrown out the window those CPI considerations when you look at all these regulations.
I know.
So we go on to sustainability. This was an interesting one. So now an owners corporation and its association, environmental sustainability must be considered at each and every annual general meeting, and then an owners corporation or this association considering the annual usage, expenditure data, having that sort of reported, having a capital works fund planning provision for including sustainability. Now, in that respect, it also says that bylaws can't now prohibit sustainability means unless it's a heritage building such as solar panels, etc., just on the basis of appearance. Now, the legislative sightings are there, but looking at this, we thought this was only for new buildings. Now, I know initially they talk about solar and EV charging, but I think this goes more into energy efficiency in existing assets. When we're looking at existing mechanical exhaust, and I mean, we were great to see a lift in a building being upgraded and its energy efficiency rating coming. So there's a lot of these things.
It talks about everything in the building, Paul, away from water usage, heat pumps, LED lighting, pressurizing, air conditioning, all those things. It relates back to all of that. And I think what's driving it is some statistics that may interest your clients. Is that we know that by 2030, 50% of the stock in New South Wales. Now we know there's 89,000 registered strata schemes in New South Wales, about 1,010,000 lots, but 50% of that's going to be over 50 years old. And so with the new Strata Hub being introduced 2 or 3 years ago, we're now collecting data each year, and we're reporting data to Strata Hub. Some of the data we're reporting is trust funds. What amounts in the trust funds? Number 2, do they have a capital works fund plan, and are they complying with it? The government's seriously looking at this stuff at the moment, and I suspect, as we all know, there's another range of 200 measures they're looking at to implement over the next couple of years. One of them is to understand what the stock looks like. Is it being maintained correctly? Have they got a maintenance program in place? Are they looking at the statutory requirements around sustainability in and around that and planning for it? Now, Paul, I've met recently with a lot of the energy companies in and around this motion, and it's interesting because one of the sexy things at the moment is EV chargers, and how does a building retrofit for EV chargers? And it's going to come. The government's electrifying everything. It's going to come. We can't fight it. But what we're finding is when they go in to install these EVs, the power box within the units doesn't have the capacity. Thinking 50 years ago when they were constructed, most people didn't have air conditioners. They didn't have electric stoves, had gas and all that sort of stuff. So the capacity of the power box within that unit won't support the upgrade of all the energy requirements with the new inventions that are coming in. Not to say that even the sub station down the road, it can't support it either. And so there's a big issue in and around that. So I can see where the government's coming from on this one. I can really see where they're coming from. And there's a lot of work, a lot of planning. I think strata managers are going to have to work hard with their committees for them to understand this and plan for the future and save a little bit of money now rather than a special levy, if you know, because everyone hates that word, special levy.
And I'm going to fall on the other side. Is the one thing we note is It's not mandatory to do these works. It's just
No, it isn't.
mandatory to consider it. But it seems as though the electrifying world we live in is creating sustainability measures, that is creating technology, enhancing that through. And again, I'm going to say here is we are probably one of the oldest states in Australia with the oldest strata schemes. To give the example, you know, I always say strata was invented in New South Wales, basically. But what it's going to show is it doesn't mean you're mandated to put in EV charging or solar panels, but it's also looking at, if I'm replacing lighting in my common areas, can I use LED lighting? What is the energy efficiency? If I'm using looking at air conditioning units, what are the efficiencies? That, to me, as a strata manager for many years, looks at that and says that is also considered efficiency and sustainability in that respect. So I think there's a lot of components. I think the good stuff that we always see is solar panels, EV charging, etc. We can look at more of the components of the building. So
yeah, Paul, it's about planning. I think it's all about getting the consumer to think about and plan for the future, because ultimately you're trying to make your asset resellable. And if you've got this in place and you're planning for the future and you're starting to install these sustainability things, saving money and all, you know, we know with commercial entities, there's a neighbours rating, and that's quite popular now when people are moving in. We've tried to implement, or the government's tried to implement, a rating system for residential. It didn't get a lot of traction. I think this is the next lever they're trying to pull. So you'll have a
But this
rating.
is for all schemes, Scott. This is that's not commercial or new devs. This is for all schemes.
Yep, I know it is. But this is trying to push it down the residential side now, where many of the commercial entities have already gone through this process.
Yeah, right. Well, I mean, but you know, you got the 10-year plan, and if you know, we see later in the year, we start seeing some formats of how 10-year plans are going to be prepared. I think that's going to be better support, but it's probably between now and later through the year getting to know our assets and undertaking that. Now, a lot of our
interesting
owners,
on that comment. Sorry, Paul, interrupting that comment. The Office of Fair Trading, the government is currently looking at a standard form for capital works fund planning, and so they're looking at a standard form in and around that, and putting
I
a lot
think that
more
would
rigor.
be fantastic.
And putting a lot more rigor around the people who are producing that suitably qualified person. And I think we'll be heading down to what's called a sustainability audit of your building. I think that's where we'll end up going. Is there a sustainability audit of your building? And they'll come back with all those sustainable measures that we need to look at.
Well, I think it will work well, Scott. The more standardized formatting we can get for these mandatory reports, it would help our owners as well. I mean, I know I do speak to various owners and they do talk about, can we just get that standardized report? Because it takes me quite a time to ingest their format and how they're advising. So I think there'll be a real endorsement. And then when we talk about an agenda having a capital works fund plan and a sustainability motion, eventually they could work hand in hand as well to really make it more efficient in terms of the building's operations and consideration. So we will have these items on the agenda, and for our committees in attendance, if these items come up, feel free to reach out to your strata manager and include an item of discussion if you've got an AGM coming up and would like us to look at your electricity accounts, your annual energy costs, and have some sort of report there as well. We'll be more than happy to do that. We are in learning stages in terms of this because it's not specific, but look, you know, it's always something we can help, and why not be the first cab off the rank in that respect. Scott, we're going to go into some provisions here, and I think touching on this, we just discussed that. Developer accountability. Now, there's a lot of discussion. This has been going on for years, but this one is very interesting, is multi-story schemes. So imagine we're looking anything sort of over the 2 stories, you know, the class 2 aspect of buildings. But it's going to be essential for the developers to engage or hire an independent surveyor to validate the initial maintenance schedules and levy estimates. So proposed budgets and the maintenance schedules, and engaging a independent surveyor, and hey, non-compliance, the penalties will apply. But I'm actually all for this because I think this is actually going to work to the client's interest by having an independent surveyor do this, because it's going to set some boundaries and cost guidance.
Oh, certainly, it's going to take away the sense of you know, there's a conflict between the developer and the strata managing agent. So they'll have an independent person setting the budgets and stuff around that. I think it's a good thing. It's a good thing, and it's the next step that the building commission is, worked out in new developments. And so, and as we know, buildings are going to get bigger. The government policy is to infill. We haven't got too many green sites left in the city. And I know we're told by 2040, there's another 2 million people in the next 15 years, or just under 15 years. There's another 2 million people moving to New South Wales, either migrating from interstate or overseas. 80% of them, we're told, are going to be living in Sydney, and 80% in residential strata or some sort of community style living. And so to get these things right are very, very important.
Well, why wouldn't you want to live in Sydney and New South Wales? Look at us. Look, it's just wonderful. I wouldn't say the last few days are the best of example with Cyclone Bomb, but I would say, look, why not? Look at the beautiful harbours in the state we've got, definitely. So when we look at, if you're involved in a new strata scheme or you're looking for advice, we're here to help you. But we would be looking for aspects of ensuring that there's high quality of documentation. Your budgets or your proposed budgets should be supported with some backing information and some sort of financial planning and independent oversight. So it's definitely something we would be looking at and presenting if we are at a first AGM, but be sure to ask that question if you're unsure. Make sure it's attached to the notice of meeting, in my opinion. Scott, I'm going to go over to accessibility infrastructure. This one's sort of come up and opened itself up in terms of where it came from. Now, commonly for anyone in a mixed use, a commercial industrial scheme would probably be very familiar with this. But to me, wrong is the voting threshold has reduced. That has gone into the provisions of an ordinary resolution. So we know additions and alterations, not more than 25% of votes cast against, but in layman's terms, 75% or more of the unit entitlement. This is a 50% ordinary resolution. And when it's being proposed in the imagery you got there is common aspects of maybe handrails, chairlifts, ramps, etc. Schemes, all schemes must consider the installation and these key criteria costs of application of costs, access and equity being forming part of the asset, the type of access it's giving and the costs associated, then the aspects of liability, etc. before they vote. But it's really applicable to all schemes now from what this legislation says.
Indeed, Paul. Let's just look at the demographics. And just look at my face on this screen. It's me that's driving this. It's the baby boomers who are downsizing. They're moving into residential strata. Again, we don't really understand residential strata. And the government policies now is to keep people at home as long as possible. And the support they're providing to keep people in their own home. Importantly, I think it's a good thing because it's much cheaper than putting them into a care facility of some sort. Now, the whole thing around that is to making that lifestyle or the accessibility of a residential strata scheme easier. And I think this is what's driving this. The baby boomers, the ageing society, people downsizing to residential strata and needing that handrail, needing that chairlift, and what's reasonable. And this is what they're coming with. Before we hid behind a special resolution, it could be easily defeated. Now it's just an ordinary resolution, which means 51%. I think that's where the legislation's coming from, and I sort of understand why they're bringing it in.
And I mean, when we look at this, it's important to recognise is we've got to consider it's now the word equity access being used is acknowledging forming part of the structure. So there's no doubt in terms of due process, I think what we look at is making these consideration, improving access to areas, simplifies the process in a more inclusive community.
And I would say too, and what we're finding more through the New South Wales Civil and Administrative Tribunal, where people are taking these matters on, look, there is a very friendliness from the tribunal, and they're looking at the word reasonable. Now, that's a legal word. What you might think is reasonable, Paul, I might not. But yes. But that's what we're dealing with, and we need to get together as a community. And it's about community living. And Australians aren't very good at community living. We weren't forced like the Second World War, where half of Europe and Great Britain was bombed, and the only way they could get people housed in a quick way was to build tenements and blocks of units. Now, there's generations of people who've lived in it, and they're sort of used to that lifestyle. Australians aren't, and it's something we really need to get our head around and understand that people need different levels of assistance or accessibility to their residential domicile.
But I would say we're becoming more adaptable. I mean, more and more people I speak to are sort of adapting to the lifestyle in these schemes and associations. And I think communities are developing strongly too, Scott. When you look at this, you see them really developing in ways which are quite excellent in terms of creating community environments. So I think accessibility says I can stay there longer. It's applicable in a scenario to all schemes, not just commercial industrial there. So it will be very, very interesting there.
Yeah, it is. And community, you're right, is changing. I know my son's 28 years of age. He said, Dad, I can't afford to buy a house. It's going to be a lifestyle of choice moving into a unit because it's more affordable. And he said, I wouldn't want a house, Dad. I see you cleaning the gutters and mowing the lawns. I want someone else to do that. I'll pay them to do it. And then, of course, older people are downsizing like me. We're downsizing because we can't mow the lawns anymore. We can't get on the roof to do the gutters. So it's an interesting demographic. It's changing. The world's changing. And, you know, as I say,
a lot more fast-paced as well.
Well, Paul, I always say it's very interesting, and I wear the Strata Manager's badge on my heart because often people say that we manage buildings. We don't really manage buildings, Strata Managers. We manage the people who live in them, and that's a bigger challenge.
Communities,
yeah, because the building very rarely rings me. Maybe a fire alarm. It's the community, the people who live in there, the owners and the renters.
Right.
You know, and that's where the challenge is to make them understand these sorts of things.
Definitely. Now, we're going from accessibility to really looking at assistance animals. Now, I thought this was initially addressed, Scott, you know, and we saw a lot of the aspect of the prohibition bylaws for pets being removed. We then had applications where one change was you couldn't have a bylaw that prohibits the companion animals, support assistance animals. I think this is really much a clarification to me, and they've updated the sections of legislation. Interesting enough, they've also updated the Community Land Management Act here.
Yes,
that can be associated with associations and houses. But really saying, look, one format of ID, if it's an ID card, a permit, a council certificate is sufficient. In that regard, you know, we used to see health practitioners' letters, etc., but they're using this to clarify the point of it, just simplifying it for those people with that regard.
Yeah, I agree with you, Paul. I think ultimately you cannot unreasonably deny someone having a pet or an animal. I think this has gone some way to further clarify, to close little loopholes that certain people were looking for. And boy, we've come a long way in the 20 years or 23 or 4 years I've been doing. I remember one of the first plans I managed, we used to have a weigh-in at the annual general meeting for the dogs. It had a scale. The dog wasn't allowed to be over a certain weight. And I loved going there the week before when all the owners were running their dog around the park across the road. But certainly I think this piece of legislation is just clarifying and fine-tuning the way that the community wants to go, or the government certainly wants to go.
Thank you, Scott. And I think that's a good point of clarification that will be used. And also having the pet applications updated will also make a lot more easier. When we talk about applications, it's really just about notifications in that respect. Interesting one here. Minor renovations, floorings, kitchens, in that regard. The real change is coming to say if the committee fails to refuse in writing within 3 months within reasons, minor renovations are automatically approved. And then we've got to keep records for 10 years.
That's interesting, isn't it? So 10 years, that's interesting, isn't it?
Well, the statute says 7, and we've got a 10-year provision here.
Yes,
but
all other records for 7 years, this one for 10 years.
But I don't think anyone in our sort of organisation and our clients actually don't respond within the 3 months. I think the facilitation is there, but it's really looking at the automation of approval, maintaining that. Now, Section 110 being updated is really covering off renovations, but it's really important to me when I look at this is having bylaws for your minor renovations and having that delegated to the committee. I sort of look at this and it references a committee, but unless the committee has that delegation, has to go to a general meeting for the owners corporation to have an ordinary resolution. So this is quite going fast, and we're going to need to have our schemes look at putting these bylaws in place to delegate the authority of minor renovations to the committee, wouldn't you say?
And I agree, and I think you as a company, or all the companies in New South Wales, need to have some sort of thought or a process or a policy around how they're going to record this information, and so it's readily available. And I guess hand in glove, it goes back to a statement I made a little earlier that 50% of the stock in New South Wales by 2035 or 2030, sorry, I should say, is going to be over 50 years old. And so there's going to need a lot of work in and around it, you know. So minor renovations are going to be increasing as young people buy into units that they want to get rid of the 1970 fawn tiles in the bathroom or kitchen or whatever. So it's a very interesting
Well,
change.
I would say they're coming back. Those designs I've seen are coming back into fashion. Like, I mean, it's quite interesting to see. I love seeing these applications and the absolute creativity.
Yeah,
But I think also what we've got to look at is procedurally, I think we
correct.
implement a process in record keeping. The interesting part is, 10 years. I mean, look, your best way of doing this, and I would say this to any scheme or any committee, have it at a duly convened committee meeting if you'll delegate that authority. Have the application annexed to the notice of meeting. Have those minutes. The records, I know they say 7 years, I know they say 10 years, but good strata managers, good schemes keep their minutes for the life of that building. And that is your sort. You can have any register, any database you require, but having a good set of record minutes, even if they're circular resolution written votes, great idea, because that there, I know for us, we retain those minutes forever. This is not just an invoice. It's not an accounting practice. This is, asset schemes. So to me, I think, we'll issue reminders and do all of that, but make those decisions at meetings, working with your managers, good, succinct, clean records. I'm going to say 6 monthly reporting by strata managers, they're going to have to put this in here. We're going to have those reportings in there, and we will. But what a great way to do that.
It's like a history of yourself. You record the history of yourself. Your building's important, and I think the history of your building should always be recorded. This 10-year,
are you relating minutes to diaries there?
Well, I think it tells a story of your building. And the committee at the time, they had this view or this pattern. This is what they wanted to do, and I think it's a good story in itself, and it's best practice to keep those records.
Definitely right. So look, watch this space. You'll see a little bit of changes in that regard. Note that if we're doing that for the purpose of your record keeping and requirements there. So if there's any queries, questions, feel free to reach out. Now, going from minor renovations to repairs and maintenance changes, again, I think this is a clarity being so heavily involved in the governance space and as a licensee and watching the tribunal decisions and court decisions being made. But this one's really, really interesting because the Act stated, you had a 2-year period that you could seek compensation. Now, I know there's other pieces of law and that come into place, but what's really being applied here, especially under Section 106 of the Strata Schemes Management Act to repair and maintain common property and Section 109 of the Community Land Management Act, schemes can't delay repairs if they affect the safety or access to the scheme. And owners now have an extended period of 6 years to seek compensation for maintenance failures. Now, one would say that liability was always 6 and 7 years, I think, because we had the home warranty provisions there. But this clarification of affect safety or access is really a driver that I think, who's going to make that decision? I mean, access, safety, as clarity, I think, it's a reliance on a strata manager, but I think I don't want to use the word reasonable because you put lawyers around there. But is it practical sense? Is it of reasonable means to practically consider how the impacts in that regard, Scott?
Yeah, Paul, I just think they've added a couple on your words there in terms of safety and access. I think common sense would suggest that it's fair and reasonable, but unfortunately, we often find common sense isn't common in strata, and we're dealing with situations where there's a significant amount of work that needs to be done. Now, Section 106 you reference and 109 It is a duty of the owner's corporation to repair and maintain common property, non-stop. That's it, finished. Have to do it. And of course, we're seeing a lot of actions in NCAT where owners corporation are delaying the process unreasonably. Again, there's that word. And I've just recently seen $250,000, $275,000 headed down by NCAT because a person had lost rent, had to get new carpet, had to get mould removed because they failed to act in a reasonable manner to repair and maintain common property. And as it's interesting, it was only 2 years. Now it's been extended to 6 years. They can recover costs up to 6 years. Now, I understand that starting from the 1st of July, that 6-year period. But look, I think it's just sharpening it up and pointing back to the Strata Committee that's elected. You have a duty to repair and maintain common property. Non-negotiable. It's non-negotiable.
But Scott, you just want to touch on that. Is one thing. This starts from the 1st of July.
Yep.
Right? It's not retrospective.
That's my understanding. Yes.
That's my understanding too. But I think, we always have decisions made in court appeals, etc. I don't want to get into that space. I want to talk about communities and the changes here. I don't think there's a doubt, but I think when I look at this as a strata managing agent to our consumers, our owners, we also got to take in aspect this work health and safety provision.
Oh, indeed.
And to me, if it ain't safe for you, it's not safe for me. And these are sort of aspects that we must consider.
Yes.
And this is really going to come into more and more the discussions. We know how critical, especially after last year's rulings, the work health and safety legislation becoming applicable. And in my opinion, as a professional here, as somebody that cares, I would always say as an organisation, it applies right across the board now. It's not just because I've got a restaurant there or I've got an office. It applies right across the board, would you not say?
100%. And the courts are even handing down decisions in and around that. So, look, and unfortunately, in many ways, New South Wales is the most litigious state entity in the world. They tell me now it's even bigger than California, but you have an obligation. We have an obligation, the strata managing agents, and the owners corporation have an equal obligation for work health and safety within their owners corporations.
Thank you, Scott. Now we're going to go on to a completely different network, and we're going to talk about embedded networks. Embedded networks, embedded networks, embedded networks. Now, for those that aren't familiar with an embedded network in a lot of schemes is one utility service provider. That then contains like your things of electricity or gas. They're associated maybe with electricity, central gas heaters, implements, or cooling towers. And you don't necessarily receive an electricity bill or a gas bill from your utility service provider. What you actually do is your levy contribute to that. And owners have been very limited in the options they can use, and there've been these long, huge contracts. Now, schemes must disclose embedded networks in arrangements in the sale of contracts. So there's no doubt we're going to see conveyancers, owners asking for if they have an embedded network or is it in a contract. And my key tip there is look at it and see if you've got an independent electricity bill addressed to you or a gas bill. But this is not only just utilities. We're talking about things of communication services, water, gas, not water, bad
hot
example.
Hot water is now in
hot water,
yeah.
That's right, yep. Gas, electricity. But what I'm actually pleased to see here, Scott, is these agreements, if you're a new scheme, they will expire at the first AGM to give the consumer, the owner, the opportunity to go to market and see the appropriate measure, which then means the embedded network providers compelled to give a month-by-month contract until they decide. But the other one that is really solid here is the 3-year application from the starter agreement. Now, the way I read this is it's only applicable from the 1st of July. It's not retrospective. But what it is it's applying to a 3-year cap on all these utility contract terms. And I think we're going to see later in the year, this is going to be applied to all utility contracts as well, a 3-year cap. So this is actually a welcoming change, in my opinion. But the disclosure requirements don't stop there. The certificates need to be updated. The Section 184, the status certificates when they're selling, there's an additional point of disclosure. and we're going to have to disclose this information. So I think as an industry, this is a welcome change. I think it's a time when we look at this is welcoming this change, having a good contracts register. You know, we've talked about unfair contract terms.
Yep.
We've then talked about routine contracts, embedded networks. Schemes are going to really look at heading towards having contracts registers. And I think I invite this to be able to manage their contracts and reminders in that regard and be able to effectively manage it. But we're talking stormwater, sewage, recycling,
Yes.
EV charging. This is all happening. So it's time to do that. And hopefully with the support of SCA, we'll be able to see some sort of standardised contracts come into place as well. Now, I'm going to proceed into this one here, is record inspection fee increases. I know the SCA had something to say with this, but inspection of records. Now, for non-owners, they've doubled these fees. I guess an owner, for everyone, is clarified if you're attending this webinar, your name's registered on title, you
Yep.
are an owner, a nominee if you're contained on the strata roll. Actually, for owners, it's reduced for you. It's gone down from $34.10 to $31.
Yes,
And
big
then
10 cents there, Paul. Well, don't spend it all on the one shop, though.
It's the first time I've seen legislation apply the word inclusive of GST, so it was quite inviting because I think
Yes.
whenever we saw these, we scratch our heads and say, is that GST included or is it on our business status? What is it, you know? But for representatives, non-owners, that fee has increased. Now that's gone up from that $31 plus GST to $60 inclusive of GST, and each half hour after that is $16. Now, they've really clarified, and this is the first time we've seen this. Correct me if I'm wrong here, Scott, but
Yep.
applying electronic access.
Yes. Yeah.
So
it's a change to the previous
access.
legislation, yes.
So we're really getting into the world of electronic means here, right? So these are one things that is probably more applicable to inspectors, but owners that do their inspections, etc. This is one thing to look at in that respect. So applicable to community associations and strata schemes so far, because they're prescribed in that. And then we can go from there. So 1st of July, look, I think apart from the fee increase, and I know I touched on that, we're sort of implying the view of improving access integrity, ensuring fairness based on the user type, but also acknowledging the electronic means. So I think that's coming quite wonderful in that respect. I've got some hot questions, so I want to sort of come through in that respect and run through all of this there. So proceeding with when we're looking at committee duties and chairperson functions that are changing.
This is a good change, Paul. I think this is a good change.
Yeah, I think this here to me, look, I have a lot of questions come up with what strata committee training's looking like. Now, again, I thought we would have seen that in the 1st of July for committee members. But
they're telling us third quarter, Paul. They're telling us third quarter.
Okay.
I'm not sure what the training is going to be.
Well,
I've asked that question.
Quarter, or?
Third or fourth quarter, yeah, sorry, third or fourth quarter, October, somewhere around there. They're talking about strata committees will have to complete education, and then if they fail to complete it, this is what the current legislation is saying, they'll have to stand down from committee. Not sure what it is, how it's going to be delivered or where it's going to be delivered, but this is what they're telling us.
So section 3742. So I'll get into the changes now in terms of what they're detailing for committee members and specifically to chairpersons. So we will anticipate to see more details on strata committee training, and they'll, again, it's not us pushing it, but it's, they did mention it will come through to third or fourth quarter.
I can say, Paul, the SCA does have some online training for committees. If they want to reach out to us, we can certainly point them in the right direction. So
you've got new committee member duties there, honesty and fairness in carrying out their role. This is being written in terms of the legislation, due care and diligence, benefits of owners, corporations, and I think associations as far as practicable, comply with the Act and regulations, information use. So this was a key that if a committee member is handling a matter with an owner or being approached, it can only be used for the committee purpose only in that respect. But then it comes on to the chairperson's functions being changed here and sort of being extended. They're writing in terms of following the agenda at meetings. So you're chairperson of the owners corporation. If you are chairing those meetings, following the agenda at the meetings, maintaining order at meetings, encouraging fair, constructive, open discussions, and facilitating discussion by meeting attendances. So they put a bit more structure in here, but this part here I actually thought not only is for a chairperson of a committee, but also could be applicable to strata managing agents that maybe delegated the role as a chairperson at that meeting. I actually thought that was quite interesting to see. So I know what we've sort of looked at is creating a handbook to assist and circulate that through shortly after this, but this is quite interesting to say, look, we've got to follow the agenda, but I sort of see this has got to be reciprocated in both ways in what is the agenda about, keeping that sort of, I guess, relative, but also ensuring there's fair, encouraged discussion. And it's going to sort of encourage sort of more guidelines to meetings and how they're conducted, especially as schemes get larger.
Yep. Yeah, but you know, some of the larger schemes would be nothing to have 300 or 400 people sitting in a meeting, and trying to chair that meeting can be quite challenging at times, particularly if there's some controversial activities or motions on the agenda. And it's a challenging job for chair people to do that. And I know your company does a lot of training with your strata managers on how to facilitate successful meetings as chairperson. And it's a thing I think since COVID, I can tell you there's been a lot of changes in the behaviour of consumers. And I think you'll see as you walk into many different stores and so forth, please, you know, treat us with fairness and honesty. And this is just trying to give that back to owners corporations and give a little guidance to the chairperson on how to deal with matters fairly and equitably.
And this will also be applicable to committee meetings as well.
Oh, yes. Yeah, absolutely.
And I think it would also sort of change the format of minutes from time to time. If you're performing the functions of secretary and you're having these discussions, it may require, and not all will agree, but maybe notations to the point of discussions that were held or handled on certain matters would actually be very important here. Which, you know, recognising and supporting the chairperson in that respect, in terms of making sure was there discussion, not so much who said what, but acknowledging their discussion held by the owners in certain items. We'll probably see a more common aspect in minutes. So I find it interesting, but look, you know, I think it strengthens good governance, not just the sort of shutdown approach, but it allows well-managed committee meetings and owners corporations meetings in that respect will be very important. I know for our strata managers, there is aspects to a guide that we've provided, and I think it has to be reciprocated both ways in that respect. I've got some time. We've got some time for question Q&A here. I might sort of read them out, Scotty, and see what we can do there. Yes, the slides will be shared after this meeting, along with the recording and some supplementary information. I've got a question here is, who is going to provide training and how much will it cost and who pays? Scott, I'm gonna put that to you because I would be really interested to see. That hasn't been clarified.
No, it hasn't. I've asked each one of those questions only 2 weeks ago to the Office of Fair Trading, and they didn't have clear answers for that. They think they're going to produce the training electronically. I raised my concerns that there's a significant number of strata committee members that may not have the ability to do it electronically. So they've gone back thinking about how they're going to do that. I'm not sure what the topic material is going to be and who's going to manage whether the committee member completes the training or not. Who's going to pay for it? Well, I suspect the owners corporation will pay for it. If they're electing a strata person or a lot owner onto the committee, it'd only be fair and reasonable that the owners corporation would pay for that training. As I suspect with most of the changes that's come through, there is an element of additional cost related to many of the things that are going to be implemented. And of course, Paul, I don't want to scare your clients, but there's another 180 changes being looked at the moment that are going to come in the next couple of years as well. But anyway, maybe back to the questions at hand.
And I mean, I look at this and look, you know, in terms of provisions we've got a lot of questions in terms of animals and benefits, etc. I think what I would like to do is sort of encapsulate them, and we'll provide some direct response there. But there's one very interesting one here. Will bylaw updates be mandatory to comply? Now, the last mandatory review of bylaws was made in 2015 and 16 when the legislation had a full overhaul. It's not mandatory, though what the approach they're taking now is to advise that bylaws can't prohibit, they cannot restrict, and cannot be basically in contravention of any other legislation. So when we look at section 139 of the Strata Schemes Management Act, and also the aspect of Community Land Management Act, they're really applying that these bylaws are no longer applicable. So what we've got to be able to do is review those specific bylaws. Whilst not mandatory, I think it's taking a different approach in terms of specifically addressing a specific type of bylaw and then acknowledging that and making that review. Now, we've just hit the 7 p.m. mark, so I've got a whole bundle of questions here, and we will promise, I think it was 29 of them. We will definitely have these answered. If they weren't answered live, or if they were answered live, we will definitely be producing responses with this webinar. This webinar was recorded. I want to thank you, Scott Martin, for attending, taking your time out.
My pleasure indeed. It's a lot to get across, and I feel the pain for the consumer, because us as strata managers, we struggle to try and get our head around the myriad of changes, but not only the myriad of changes, what they're trying to do. And I think one thing I'll take away in summary, Paul, is transparency is the key here, isn't it? It's about being more transparent. Yes. I'm for that. I'm an old banker. You know, many years ago, there was no degrees of honesty. And I think being transparent when you're dealing with people's funds and functions that are spending those funds, it's important that we can report all these things, because you can't be half pregnant, mate. You're either pregnant or you are pregnant, or you're transparent or you're not transparent. That's my view. And I think it's a good, generally overall, I think the intent of the government is positive.
No, definitely. And Scott, fantastic closing remarks. I want to thank you everyone for your attendance. Look, if there's any questions, feel free. I think there was an email. I think it was hello@jamesons.com. Shoot that through. I wish everyone stay warm tonight. And we'll have this through. And thank you all. Have a great evening.
Everyone. Best
Bye-bye.
wishes.